In Bobby Pryor against Silverline International Limited, the claimant brought a claim for personal injury arising from a road traffic accident. Allianz insured the defendant and resolved liability fairly early on based on a 50-50 share. Damages also were resolved at a very moderate level, about £1,200 or thereabouts. The issue was all around whether or not it was reasonable to issue proceedings. The claimant disclosed their medical evidence and claimed that they had not received an offer within 21 days. It was always Allianz's position that an offer had been sent, and it was determined that the offer that Allianz had sent had not been received. But disregarding whether or not the offer was received, our argument was that the claimant should have done more to try and resolve the case without having to issue proceedings. Unfortunately for us and for Allianz, the designated civil judge in Liverpool upheld our appeal and determined that the claimant had not acted reasonably. The appeal was allowed, and the amount that the claimant was allowed to get back in costs was reduced back to the amount that they would have got had they not issued proceedings. And then also, of course, we were awarded all our costs.
First instance, the court rejected the defendant's argument on the basis that the district judge found that having been made aware of the fact that proceedings had been sent to the court, the onus thereon fell to the defendant to have done something about it. The defendant should have written to the court to suggest that the proceedings were not processed, or should have written to the claimant solicitors to invite them to withdraw the proceedings prior to them being issued. Because in this case, there was a delay of 3 or 4 days between the papers being sent to the court and the court processing and issuing the proceedings.
I think this sends a really important message out to claimant lawyers that they can no longer take an opportunistic view of just applying a tick box exercise to issuing legal proceedings. I think it's a very positive, important case for the wider insurance market, that it shows that we'll take the fight as an industry when it's justified. I hope this case is used by the industry when trying to tackle the problem of premature, unjustified legal proceedings. As an insurance company, we're in the business of paying claims. Here at Allianz, my philosophy is that we pay genuine claims, quickly, fairly, and with a personal touch. We take a proactive and cooperative approach to handling claims, not only with our customers, but with genuine third parties.
We've managed to get good outcomes on these points now throughout the country in all sorts of different courts, but it's particularly a good outcome, I think, that we've managed to get this in the Liverpool County Court from a decision that was made in the Birkenhead County Court. There has been a perception in the past that these are difficult courts to obtain rulings against this sort of process, business-like approach to issuing proceedings. So it's particularly pleasing that we managed to get a decision from the designated civil judge in Liverpool, putting down quite a robust marker.
I think this case and other similar cases that have proceeded in courts which may well have been seen to be difficult venues for arguments such as this do very much set the scene that where claimants take steps that are disproportionate, that are unreasonable, then there will be sanctions applied in relation to costs.
I think we are now seeing that the courts are taking a more proactive, reasonable approach. That may be due to increased claimant frequency or improved processes and proactivity on behalf of the insurance industry. Also, no one really benefits from this aggressive behaviour. Claimants receive the same amount of money as just demonstrated in this case. I have to instruct a lawyer, which adds a level of legal costs to the insurance book, which is ultimately passed on to the premium paying public. So it's not good for anyone. A cooperative approach and a consensual approach to picking up the phone, it's no longer us v them, is the way that we want to deal with claims going forward.